again for Cherry Hill Squares. This is another episode of our Cherry Hill Squares. And today, Lexi and I decided that we'd get together and talk about questions that have come up recently in our practice about issues related to mediation. So Lexi, I know that we have discussed, you had a question that came up recently for a client.
Yes, I have clients often ask me, should I just do mediation? And clients at any point, pre-divorce complaint or post-divorce complaint even, can choose to do mediation. And a lot of them choose to do it by themselves because they're relatively amicable. They feel like they don't need lawyers. They feel like lawyers are going to amp up sort of the potential acrimony in the proceedings. But what I have seen is that lawyers are generally a good adjunct to me as opposed to a bad adjunct to mediation, because what often happens is that parties will agree on an agreement in private mediation. The mediator is not looking out for them. That's not their role. The mediator's role is to get the parties to settle, and that's it. It's not to say, hey, this is a bad deal for you. Why would you agree to this? And so after agreements are signed, which is the worst time for this to happen, parties will come to me, or a party will come to me and say, here's my agreement. What do you think? And I'll look it over and I'll say, well, you over obligated yourself here. You didn't take enough here. This isn't what the law says. And so the best thing to do, if you want to do mediation, that's great, because being able to be amicable and try to resolve things in that type of way is a good way to approach a litigation. And by the way, you can even approach it that way with lawyers. I mean, just because you get lawyers involved does not mean that you're gearing up for a knockdown, drag out fight. But the best thing to do is either have lawyers in the wings as adjuncts to the mediation so that they can advise their clients along the way, or at the very least, don't sign anything until you can talk to a lawyer. But it's usually better to have us involved beforehand, because once there's some type of settlement framework and then a lawyer gets involved and somebody tries to get out of it, it can cause, everybody's human here, hurt feelings, expectations that weren't met. So it's really better to have us involved. I know it sounds self-serving, but it really is honestly better for the clients to have us involved at the inception, even if we don't attend the mediation,
Right.
just to be able to be there to support them. And that can be a process that's either prior to a divorce complaint, or it can be even after a divorce complaint's filed and the parties choose to go to mediation. They're never prevented from trying to settle, no matter
Right.
where they are in the case.
Right. And I think I've gone through the state's mediation training, and I certainly think that there are great qualified mediators out there, but that understanding that a mediator's role is to be a third party neutral, right? They're not there, even if they're an attorney who's acting as a mediator, they're not there to advocate for one client or one of the individuals or the other. They're there to help parties compromise. And at times, that may not end up in a result that has somebody after the fact consulting with an attorney believing that their situation is fair. And there are certainly other ways, as you mentioned, that mediation comes into play, even if conventional litigation has started, right? So as we both know, anytime a litigation is filed and there involves issues related to custody, parties are sent by court mandate to custody and parenting time mediation. And in that process, attorneys, even if they're involved in the case, aren't attending. And then later down the road, there is the process of an MESP, which is like a mediation process that happens within the confines of the court, where attorneys are advising and acting as economic mediators, at least in the initial contact with the parties. And then there's post-economic mediation, which is occurring after an MESP, where maybe the parties aren't in agreement with whatever the panel has recommended. And that's when, again, they engage a mediator from the court's list, and they're mandated to attend for a couple hours, but it is only so far as the parties want to attend, right? As we know.
Yeah, I mean, it depends on the jurisdiction and the judges. I mean, in some counties, people are never sent to post MESP economic mediation. In some counties, it's basically a foregone conclusion. There's a list of economic mediators, and the first 2 hours are free. Usually, though, realistically, those first 2 hours being free get eaten up in the mediator's prep time. So usually the parties do have to come out of pocket a little bit, which often seems unfair to them because they're essentially ordered to go to this mediation, and then they have the privilege of paying for it, but that's just sort of the cost of doing business when you're getting a divorce. But basically mediation is mandated by the court in some cases, and can also just be a helpful tool in other cases. And another thing to note about the custody and parenting time mediation is that no matter how much the clients may want us there, the attorneys are not allowed to attend the custody and parenting time mediation that the court sends the parties to. But it's also important to note for clients that you don't have to settle. So even if you have to appear in a mediation and put in a good faith effort by being there, and if nothing's going to come of it, nothing's going to come of it. Nobody can force a client to settle, as much as we may want to sometimes.
Right. Well, and it's also important to note that it always takes two parties' participation for there to be any type of mediated agreement. And sometimes the nature of you referenced being amicable and folks coming to us and saying, hey, I want to be amicable. I'm interested with my spouse and just getting this done. There are times when we have people who one side is saying, yes, I want to be amicable, but there is some hindrance to that amicable resolution because it takes two to tango. You have to have two parties willing to sit down at the table. And a lot of times I found that you can help people flush out whether there's potential for resolution via some type of alternative process to litigation by having each party retain counsel and sit down for a four-way conference where each of the parties and their attorneys start to talk about issues. And then if you hit roadblocks that seem insurmountable, then utilizing the services of a third-party mediator without attorneys present to try to help work through those issues. I find that that's most effective generally when we're talking about issues related to custody, because that's where people tend to bring more emotion to the table.
Yeah, but any option really is available to people. Some cases are not mediatable. I don't know if that's a word, but it's a word now. And
I would agree.
Some cases don't need lawyers, and they don't need lawyers. They don't want lawyers. They don't need lawyers. It really depends. But I think most cases fall into a happy medium where lawyers are necessary to assist. But really it's client directed, but also not every case needs a mediation, even the ones that are amicable. Two reasonable clients, two reasonable attorneys can largely come to the same resolution as they might with a mediation. So like I said, it's important to remember that people sometimes get their backs up when attorneys get involved. My spouse said they weren't going to retain an attorney. Having an attorney involved 9 times out of 10 is not really a bad thing.
Right. And generally,
I find that somebody is going in guns blazing.
Right. Well, and I find that it generally results in an agreement that parties are informed and understand,
Yes.
and that net result equals that they are able to move their separate ways in an amicable fashion, and they're not back redressing issue after issue after issue because they didn't really truly resolve an issue. They kind of put a Band-Aid on their problem. So
having attorneys involved provides for more of a finality in the agreement. You never want somebody to come back and say, yeah, we did mediation and I wasn't able to, I had no idea you had $1 million in that account. I want to reopen everything. I mean, so there are a lot of pluses to having us involved.
Right.
So,
well, and there's a lot of the art of compromise is not necessarily, and it's an art, and it does take a lot of work to work towards a compromise. And I think that, right, for different people need and require different levels of information and comfort in order to reach that place. So I agree. And it was great talking to you about it. And I hopefully this is a little bit of information that we can help folks understand what the nature of the processes is.
Yes.
All right. See you next time.
Talk to you soon. All right.